How many places you can refer one case law? It depends on the case law. Few cases can be utilized only for one particular section or article, and there are few cases which can be referred as many times as you want. And one among them is R.C. Cooper versus the Union of India, which is famously known as Bank Nationalization case. This case can be referred for the answer for part 3 of Indian Constitution, which is the fundamental rights. You can refer this for article 13, 14, 19, 31 and 32, or you can refer this for the answer of part 4 of Indian Constitution, that is DPSP, while answering article 37, or you can also explain this case law while answering for your question on the powers of president. Here you can use the case law while answering article 123, which is on ordinance by the president, or you can refer this case law as a background for the 25th amendment on the constitution, or this can be a background for the famous Kesavananda Bharati case law also. And this is one of the very important case law as far as banking law is concerned, where the nationalization of banks are discussed. That way, this is a very important case law. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and here in this video I am trying to explain the length and breadth of the bank nationalization case. Why to waste time? Let's get into the first slide. The entire story goes in two lines, and for one line I am giving all the notes. The other line is political line, so I am not going to give the notes, but you should know the background of that also. First, let us try understand what is that we need to know. We need to know that there is something called DPSP in our constitution, which is the part 4 of Indian Constitution. It is not like the part 3 of Indian Constitution. Part 3 speaks about fundamental rights, which is legally enforceable by the courts. Whereas DPSPs are the guidelines for the government, or the principles to the government, how exactly the governance to be done. Now, these are the welfare provisions to ensure that the state is going in right direction. These cannot be enforceable by any court, but these are very important. And on the basis of Article 37, the nationalization of electricity, the nationalization of insurance, the nationalization of oil, etc. were already being done. In the meantime, there were a lot of development happened in the banking sector also. More than 300 banks were being got closed in the commercial sector starting from 1950 onwards, and during 1969 there were 14 strong commercial banks which had almost 85% of the deposits among them, and all of these banks had minimum deposit of 50 crores with them. Now, there was a great risk of financial control by the private segment because of this, and these banks have not given any importance for the development of rural, agricultural, small scale industries or medium scale industries. Now, who has to take care of the welfare of the people? That is the government. So, under Article 37, the government started thinking of bringing the banking sector into nationalization. Now, that was the first background. There is one more parallel truth to this entire episode. Why are the nationalization of banks done in any nations of this world? It is majorly because the government want to take control over the banking sector. But in India, it was not just an economical driven activity or welfare driven activity. It was mostly politically driven activity. Why? Because during that time, after the death of Lal Bahadur Shastri, Indira Gandhi became the Prime Minister of India, and many of the Congress leaders were not happy with that, and among them few were the seniors which had something called syndicate. They all had a syndicate, and these people were not happy with Indira Gandhi being the Prime Minister of India. But Indira Gandhi had to prove that she is the able candidate, and she wanted to take control over her party. So she was always waiting for an opportunity, and this is what she has utilized to show her power in the Congress party, and that's how we got nationalization of banking. Let's continue the story with Bank Nationalization Ordinance. Now, what is an ordinance? It is the power of Indian President. Now, that is discussed under Article 123(1) of Indian Constitution, which says if at any time except when both houses of parliament are in session, the president is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinance as the circumstances appear to him to require. Now, if both houses of parliament are not in session and if there are any circumstantial decision, then he can release the ordinance. That means the President of India can release the ordinance under Article 123(1). Now, under this article, an ordinance was promulgated on 19th July 1969 known as the Banking Companies Acquisition and Transfer of Undertaking Ordinance 1969. And with that ordinance, 14 banks with more than 50 crores of deposit were got nationalized. Now, why on 19th July 1969? For that, let us go to the second line of this entire story. When I say the second line, that is the political line. What happened in political field? On 3rd May 1969, the then President Zakir Hussain died. To his place, V.V. Giri became the acting president and Indira Gandhi wanted to elect V.V. Giri as the president of India, and the syndicate was not in alignment with Indira Gandhi. Now, in the meantime, what happened? The 20th July 1969 was the last day of acting president V.V. Giri, and 21st July 1969, the Lok Sabha would begin its monsoon session. So, Indira Gandhi just had 19th July to ensure that V.V. Giri, the then president of India or the acting president of India, has to promulgate an ordinance. So, she utilized that opportunity and ensured that the ordinance came on 19th July 1969. So the entire drama happened like this way. On 19th July 1969, the President of India promulgated an ordinance by name the Banking Companies Acquisition and Transfer of Undertakings Ordinance 1969. The very next day was the last day of acting President V.V. Giri, that was 20th July 1969. And the very next day was Lok Sabha's monsoon session resumed, that was on 21st July 1969, and Muhammad Hidayatullah became the acting president after that day till 23rd August 1969, and on 24th August 1969 V.V. Giri became the president of India. That is the story politically. Now let's actually move to the case. What happened there? What was the case? It was Rustum Kawasji Cooper versus Union of India, or R.C. Cooper versus Union of India. Now, who is this R.C. Cooper, or why is he so bothered? Now, I told there were 14 banks which had more than 50 crores of deposit, and two among them were Central Bank of India and Bank of Baroda. Now, R.C. Cooper was the director of Central Bank of India, as well as he had shares in Bank of Baroda. So that was the reason he put a case against Union of India under a writ petition under Article 32. Now, who fought the case for the petitioner, that is R.C. Cooper? That was the senior counsel Nana Palkiwala. Now, that is a very important name as a student of Indian Constitution that you need to remember. And who represented the Union? That was the Attorney General Niran De and Solicitor General Jagdish Swarup. And it was decided by 11 bench judge because it was a very sensitive case, and at the end it went against the ordinance by 10-1 majority. That means R.C. Cooper won the case. Now, before we say R.C. Cooper won the case, let us try understand what were the articles discussed in this entire case in my next slide. This is a slide where we are understanding the important provisions that are being discussed under this particular case law. The first question in front of the court was whether the ordinance was okay or not okay, and it was decided that the President of India gets the power of promulgating an ordinance under Article 123(1) when both the houses are not in session. So that way it was a legal ordinance because it is enabled by the law itself. Then, five major violations of fundamental rights were discussed under Article 19(1)(f), which guarantees Indian citizens to right to acquire, hold and dispose of property. Remember, this is no more as of now, it is omitted. Now, Article 19(1)(g), which provides right to practice any profession or to carry on any occupation, trade or business to all citizens, and Article 31, which is right to property, which has a very big story. I think I have already covered in basic structure doctrine. And then Article 14, equality before law and equal protection of law. You might be thinking, what is there equality before law and equal protection of law? There are many commercial banks. Why only 14 of us? That was the question. And Article 13, which instructs the state to not make any law that violates the provisions under Part 3. What is Part 3? Fundamental right. While the petitioner was busy saying that there was violation of Article 19(1)(f), 19(1)(g), 31, 14, 13, all those stuff, the government was sitting peacefully and finally said that the bank is a body corporate and it doesn't have any fundamental rights. And that one statement brought a new doctrine which is known as the effect test. What is that? It was held that company doesn't have fundamental rights, but if the thing that happening with the company is directly impacting with the director or the shareholder, then it is the violation of fundamental rights. If the effect of the act or ordinance is impacting individuals, then there can be writ petitions which is coming under the doctrine of the effect test. Before that, there was the object text. Now with this case law, the effect test came into picture. Now remember, after this case, there was no denationalization, but the Supreme Court increased the compensation under writ of mandamus, saying that there should be judicial remedy for the people who have had loss. That was what held. Now what happened after the judgment? Let's see in the next slide. It is obvious that Indira Gandhi was not happy because in the tussle of parliament versus judiciary, judiciary scored 1 mark here. So she was waiting for an opportunity, and for her in the immediate election she got very good majority both in Lok Sabha and Rajya Sabha. So what did she do? She passed an act by name Banking Companies Acquisition and Transfer of Undertaking Act 1970, and also brought an amendment to the Indian Constitution which is known as the Constitution 25th Amendment Act 1971. The whole purpose of bringing such amendment was to overcome those restrictions as imposed by the judgment. What were they? The amendment curtailed the right to property and permitted the acquisition of private property by the government of public use on the payment of compensation, and such compensation would be decided by the parliament and court will not intervene in such activity. And there was also an amendment made on 39B and C, that is DPSP, where they curtailed the opportunity of judicial review for the violation of any fundamental rights. So with 25th Amendment Act, Parliament got everything right in place. The removal of judicial review for the violation of the fundamental rights was like killing the constitution itself. Now, fundamental rights are the biggest right that every citizen of India got because of freedom. Now, if there is a violation and if there is no judicial review available for such violation, then what is the fun of having fundamental rights? It was bothering Indian people, and then come the Kesavananda Bharati versus State of Kerala, which again fought by Nana Palkiwala, and because of this case, we also call Nana Palkiwala as the savior of Indian Constitution. And the Kesavananda Bharati versus State of Kerala case is also known for setting up basic structure doctrine of the constitution, where judicial review is one of the important aspect which remained as the basic structure of Indian constitution. Before closing the session, I just have a question for you guys, whether nationalization of banks is a gift for Indian economy or one of the biggest blunder happened with Indian economy. The answer you need to think. I don't want to make my opinion here, and with that I am concluding my session. That was a long story and I hope it was an interesting story. Remember, it is not just story, it is a very important aspect as far as law students are concerned. And with that, I am concluding this session. Thank you so much for watching my videos. Please subscribe my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.